This is Brian Walshe. His wife, Ana Walshe, has not been seen since New Year's Eve 2022-2023. He's about ready to go on trial for first degree and dismemberment of a body. What happened? And will a whole pile of last-minute motions filed at this point derail the trial? This is About the Law. I'm attorney Andrew Myers, and joining me from San Francisco this week is California attorney Yolie Medina. Hi, Yoli.
Hi, how are you?
I'm good. How's everything out in San Francisco this week?
It's fine. I have a different setup here, but it looks like I'm in prison.
I know, it looks like a jail behind you. I take it it's not a jail. You're not in jail, are you?
No, it's a sliding door.
It's one of those. San Francisco is an old city. It must have a lot of old architecture over there.
Yeah.
So the Brian Walshe case has been percolating through for 2.5 years. It is about to come up for trial. We've covered this before. This is the case. If you haven't seen us before, I'll put a link down in the description section for one of our previous episodes where we went into all of the very incriminatory searches that Mr. Walshe did immediately after Ana disappeared. He was searching how to make a body smell less, how to dismember a body, and just a lot of crazy things. So with approximately 2 weeks before the trial, a motion to change the venue has been filed, which I find kind of odd on a lot of. Do you think that would derail the trial, or would the judge just deny it?
Well, usually the motion to change venue is done when they find out that they cannot pick a fair jury. It can be done at jury selection, and that's why when we talk about the Koberger motion to change venue, people were saying it's way too early. How do you know you're not going to get an unbiased jury? But that was because there was way more publicity in the Koberger trial, I think, and it was a small town. In this case, I think the publicity was less, I think. What do you think?
I think the publicity, based on just, living in the metro Boston area in an expanded view, the publicity was fairly intense. And we're going to take a look at the change of venue motion because, it was fairly intense. There's been a lot of coverage for a lot of reasons. One of the reasons was that the same police, state police officers that handled or mishandled the Karen Reed case also, and we're going to see that in a minute, also were in the Brian Walshe case. Now disgraced and fired lead detective Michael Proctor was also the lead detective on the Brian Walshe case. So that, coupled with the fact that the Karen Reed case was huge in New England and especially Massachusetts, the tail coverage of that kind of merged in with the coverage of the Walshe case. So I've got to say the coverage has been pretty intense here, and we're going to see that in a minute.
So locally, it was pretty intense. I guess over here where I am in California, it wasn't as intense as the Koberger case and the Reed case.
Yeah, probably not. So one of the top motions in limine was a motion directed just exactly at not allowing the jury to hear anything about anything bad that any of the officers, Michael Proctor, did. So let's take a look at that motion. This is the Commonwealth's motion in limine number 6 to preclude reference to or introduction of irrelevant conduct or testifying and non-testifying police officers and agencies. So the Commonwealth of Massachusetts moves for an order prohibiting commentary, argument, evidence, or examination regarding internal affairs investigations, discipline, or related matters of any police department, the Massachusetts State Police, or any potential police officer witnesses, including Sergeant Buchanan, Trooper Keefe, Detective Lieutenant Keefe, former Trooper Proctor, Detective Lieutenant Tully, whether or not the officer testifies as such. Prior conduct is neither admissible nor relevant. Does that cast of characters sound familiar to you?
Yeah, it does. And it almost seems like they're trying to say prior bad acts are irrelevant, but that's for a defendant. Normally, the prior bad acts of a defendant. Here, this goes to the credibility of the people investigating the case, right?
I always say let's look at the footnotes because the good stuff is down there. And in this footnote, the Commonwealth has disclosed conduct involving potential police witnesses that the Commonwealth does not expect to call and requests leave to address such conduct if necessary. So obviously they're talking about who? Michael Proctor. In general, specific instances of misconduct showing a witness to be previously untruthful are not admissible for the purpose of attacking or supporting that witness's credibility. They cite some cases. Rather, a party may impeach a witness by attacking the witness's character for truthfulness only through general reputation evidence or evidence of prior convictions under that evidentiary statute in Massachusetts. There's a narrow exception where special circumstances in the interest of justice forbids strict application of the rule, and they're citing a 2020 case, which in the context of law, that's like yesterday. A judge has discretion to determine whether the credibility of a police officer is a critical trial issue and whether prior false statements in a separate matter may have an effect on the result of trial, so that the evidence should be admitted in the interest of justice. Factors to be considered include the age of the prior misconduct, the strength of the evidence of the misconduct, the simplicity of establishing the misconduct, and whether the misconduct is probative of how a police officer conducts police investigations. So I'm going to jump ahead here. The Commonwealth is not calling former Trooper Proctor, whose role in this matter was described in the Commonwealth's opposition to defendants' motion for Rule 17 summons for records from Massachusetts State Police Division of Standards and Training and Office of Professional Integrity and Accountability. So what the Commonwealth is doing here is the Commonwealth is saying, hey, Proctor had a problem. He's been dishonorably discharged. We're not even calling him as a witness, and we don't want any reference made at all to his having been dishonorably discharged after he was the lead investigator on this case. That's what they're saying. I can tell you what they're saying in the motion as to officers, plural, that the Commonwealth may call. Their conduct did not involve untruthfulness. There's been no suggestion, nor is the Commonwealth aware of any allegations of misconduct as it pertains to this defendant's case. Former Trooper Proctor's conduct and text messages in an unrelated investigation, what are they talking about? Karen Reed, pertains to this defendant's case. Former Trooper Proctor's conduct and text messages in an unrelated investigation are not relevant to any issue in this case. I don't know. Do you agree with that, Yoli?
Well, no, not really, because he showed a bias against a defendant, and I think if you show bias against a defendant, I think that's fair game. I mean, he clearly, was sending messages, that were disparaging of Karen Reed, and in that case, I think it's fair game. I mean, I think that should at least come in. And he was, in fact, disciplined for that very conduct. So how do we not,
Yeah, he was dishonorably discharged. And the timeline is that John O'Keefe, who Karen Reed was wrongfully accused of backing into, that occurred on January 29th of 2022. And this occurred New Year's Eve, 22-23. So it was 11 months later. Who's to say that Mr. Proctor decided to not be biased anymore? I don't know. In parentheses, in seeking production of internal affairs records, court noted that defendant has not shown, pursuant to the standards we established in our Wyanus opinion, that events after the commission of the alleged crimes are either relevant or likely to be helpful in resolving the question of his guilt. Former Trooper Proctor's role has been documented. Other officers were present at the interviews. Witnesses have testified or been re-interviewed, and former Trooper Proctor will not be called to testify by the Commonwealth. So what the Commonwealth is doing here is they're trying to back away as far as they can from Proctor. They're not calling him. They're saying that anything that he did was either observed by other officers or all the witnesses were re-interviewed. So Proctor had nothing to do with it. We don't want to hear his name. We don't want anything to do. We can present this case without him. That's basically what they're saying.
Well, didn't Proctor get search warrants? He signed search warrants for certain things?
Well, he did and he didn't. He did and he didn't. There was an issue about the phones and tablets, one of them belonging to the 6-year-old son of Ana and Brian Walshe, which is where the incriminating texts that we talked about in previous episodes, plural, and also the phone, the telephone. There was an issue as to the Commonwealth's police officers were actually talking to the attorney for Brian Walshe, and the issue was she said orally in an email, sure, you can go into the phone, but she had limited the scope of that. And so they're saying, well, we want to limit the scope of what's coming in. That argument did not go well in a motion earlier this year in 2025. But the Commonwealth clearly is just trying to say, his role was documented, but other officers were there. We re-interviewed the witnesses, so we don't want even any mention that he had anything to do with this case. And so now it's up to the judge. And based on prior rulings, my guess is that he'll probably go along with this.
I don't know. I suppose because, there's the other thing is the prejudicial nature of his conduct in the Karen Reed case. You could say it's overly prejudicial to have him in the case because, defense counsel might want to attack him on things that he never did in the Walsh case. You know what I mean? Yeah.
So the thing that they're asking for here in the final paragraph, I usually read the last paragraph first before I go backwards, but the Commonwealth here also seeks an order precluding reference to or examination about any internal affairs investigation, discipline, other investigation, or sustained findings of non-testifying police witnesses. Where a witness does not testify, their credibility is not a crucial issue, and reference to any findings would constitute hearsay. So I think the Norfolk County District Attorney's Office, which handled this case, has been really stung by the Karen Reed acquittal on the 3 major charges that she faced. And I think that motivates them to just say, look, we don't want anything to, we're throwing up our hands literally. We don't want anything to do with Proctor. We don't want any mention of him because, I was not in the jury room, but I've heard some of the jurors speak, and it would seem, whether it was outright or subliminal, the role of the officers and the questions swirling around them had to have something to do with the Karen Reed acquittal. I would think. I don't know. What are your thoughts on that?
Well, I just think that they didn't prove that she hit him in the Karen Reed trial. I just didn't see that. And as far as the conduct of the officers, I think the bias kind of went along with not being able to prove it because, they brought these charges against Karen Reed and they, in my opinion anyway, and in the jury's opinion, they couldn't prove that she hit him. So I don't know what the judge is going to do in terms of this motion in limine. What do you think?
Well, I don't know. My guess is that he'll allow it. My guess is that he'll allow them to sanitize, but I should never be I should never make a bet like I made that bet with Evil CJ, which I'm in the process of losing. So let's look at the real monkey wrench that's been thrown into this case a little more than 2 weeks before trial. Trial now being set for October 20th. October 20th. And here is a motion for a change of venue at this late moment. I would think this is a very late moment. I can't think that a judge would be overly thrilled with this. Now comes the defendant, Brian Walshe, and moves that this court, pursuant to Mass Criminal Rule 37B1, grant the defendant a change of venue for trial outside of Norfolk County, or if a change of venue is not granted, to order that prospective jurors be selected from outside Norfolk County. Now, California, where you are, is a huge state. Massachusetts really isn't. So, I mean, to drive from Boston to Albany, New York, at the end of the Mass East-West Turnpike, only takes 2 hours. So it's not a big state. And the media, it's true that Western Mass has its own newspapers and TV stations, but I did live in Springfield for a year, and Springfield is, a lot of them are New York Yankees fans as opposed to Red Sox fans, and they're not big fans of everything inside of Route 128 or 495, I should say, in this particular case. But the point I'm trying to make is Massachusetts is a relatively small state, and either to change venue or to bring the jurors in from another county, I don't know if that really is a remedy. The motion is grounded in the belief that the defendant cannot obtain a fair and impartial trial within Norfolk County, and if forced to be tried in Norfolk, cannot receive a fair trial if persons residing in Norfolk County are included as potential jurors in this matter. This request is based on 1, voluminous pretrial publicity, 2, the unique facts and circumstances of this case, and 3, the shocking allegations that have been reported in the media and the subject of podcasts, they're talking about us, since beginning on or around January 4th, 2023 and thereafter. January 4th, 2023, I believe, is the day they finally caught up to Mr. Walsh, who previous to that had, made up excuses. She took a ride share and she got on an airplane and she went to Washington, but there was no ride share and there was no record of her getting on an airliner. So as grounds, therefore, the defendant states the following. The defendant is charged in 3 indictments that, in summary, allege that he caused the death of his wife inside their home in Cohasset. That's just south of Boston, folks. It's a very nice suburb. On January 1st, 2023. Dismembered her body inside the family home and thereafter scattered her remains in various locations, including trash dumpsters. Cohasset is a town located in Norfolk County. Potential jurors in Norfolk County have been exposed to extensive and prejudicial publicity concerning this case through broadcast, print, social media, and podcasts. 4, the extensive media coverage began on or around January 4th, 2023, when Ana Walshe was reported missing, and continued thereafter and continues to this day. And that's all true, I recall it. The media coverage and repeated references to the allegations have continued thereafter for over 2.5 years. The publicity has included prejudicial facts and characterizations of the defendant and his past involvement with an unrelated case. 7, the publicity has detailed both what is factually known, but in the great majority of the publicity has used speculation to effectively convict the defendant of the allegations without consideration to the presumption of innocence. I don't know if I agree with that one because, I don't know, maybe I overthink it because I am an attorney and I've always said on this podcast, whether we're talking about Karen Reed or Brian Kohlberg or anyone else, all of those accused by law enforcement are deserving of the presumption of innocence. I've always said that. I would like to think that potential jurors and people that are watching TV also think that, but what the defense attorney is saying is it's not true. I don't know. What do you think?
Well, I mean, over here in California, there wasn't a lot of talk about the Brian Walsh case. I mean, it comes up every now and then, but I guess in your area, it would come up, I mean, a lot because it's local. So, I mean, yes, he's innocent until proven guilty, and I'll always say that about somebody that's been charged with a crime, especially after the Koberger case. But one thing that I haven't seen as much is mainstream media talking, like, for example, Court TV or Law and Crime, talking about Brian Walsh as a monster or horrible, look what he did. He dismembered his wife. And, I don't see a lot of that. I don't know. Do you see it?
Well, not in those words that he's a monster, but he has not been portrayed well, I'll say that. His wife has been portrayed as a, up-and-coming, vivacious, attractive, young woman who came here as an immigrant and learned to speak the language fluently, and she had an extremely responsible job down in Washington, D.C. in real estate, and so I myself personally have not heard the monster word used, but I understand what the defense attorney is saying here. I don't necessarily agree, but yeah, there's been a lot of publicity. He points out in number 8, it is believed that the potential juror pool has been tainted, is biased, and cannot be impartial. 9, it is expected that publicity not only will continue, but intensify even more as the trial date in October, approximately 3 weeks away, I'd say closer to 2 right now, approaches and will continue throughout the trial. 10, the defendant was recently violently attacked and stabbed in the Norfolk County Sheriff's facility in Dedham, requiring hospitalization. There is no reason for the vicious attack. It may very well be the product of the depiction of the defendant portrayed in the media. Well, that's true. But the story was sort of downplayed. It wasn't played as much, and I frankly don't see how that plays into the factors that are taken into account in determining whether there's going to be a change of venue.
Yeah.
In support hereof, the defendant has attached a memorandum of fact and law. In support of this motion, the defendant will file a supplemental pleading on or before the final pretrial conference that includes and incorporates examples of the pretrial publicity that, due to its sheer volume, has taken more time than was anticipated to collect and organize the information. Accordingly, the defendant asserts that the prejudicial publicity will make it impossible, even with the extensive voir dire, to find a fair and impartial jury. The defendant therefore moves, pursuant to Mass Rule of Criminal Procedure 37B1, that states where there exists in the community where the prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial, for a change of venue or alternative relief, the defendant sets forth both state case law and federal cases to support his request. And they cite a case that it parenthetically says, I don't know why people put stuff in parentheses and footnotes, because that's where the good stuff is, because it says, there can be no justice in a trial by jurors inflamed by passion, warped by prejudice, awed by violence, menaced by the virulence of public opinion, or manifestly biased by any influences operating either openly or insidiously to such an extent as to poison the judgment and prevent the freedom of fair action. End
So
quote.
is this going to be heard on, when is this motion going to be heard?
Well, the final pre-trial is scheduled for October 7th, which is only a couple of days away from us recording this. And so I can't imagine, this having been filed by the defendant just this week, I can't imagine the Commonwealth is happy that, they're given, a week to object to this. And then I can't see a hearing, happening on October 7th. I can't imagine that. I mean, I would be not happy is the nicest word I can think of. Would you be happy if something like this was foisted onto your desk this close to the day of the event?
No, I would not be happy. I would I mean, I wonder if the defendant met and conferred with the other counsel about this.
I just can't see it. In the Koberger case, Idaho is a fairly large state. It stretches from the Canadian border all the way down to Nevada, and it was said to have been a 5-hour drive from the Moscow court all the way down to the Ada County Court in Boise. Whereas in Massachusetts, I mean, you know, like I said, from Boston to Albany is only 2 hours. Norfolk County up to Essex County, where my Mass office is not that far. The biggest obstacle is the Boston traffic. Worcester, or Worcester as we say, is, you know, depending on traffic, 45, 50 minutes. Springfield is an hour and a half, 2 hours, depending on traffic. So it's my point is it's not that big of a state. And the Globe and the Herald have reach way beyond. When I lived in Springfield, I still read the Herald. Bad habit, or a habit that was gleaned from all those days of riding the subway into college or my jobs at that point. So my point is it's just not that big of a state. So I don't see a change of venue, either moving it to a different county or busing in jurors from another county. I don't see those as good alternatives. And in the motion, the alternative that was suggested, or those were two of them, was that the attorneys wanted to do very vigorous voir dire, which I guess, you know.
Yeah. In some jurisdictions, I know they don't do a change of venue unless you can prove at the time that you're selecting the jury that you can't get a fair juror. And like, for example, 90% of the jurors will say, I can't be fair in this case. No, I can't be fair and impartial in this case. And
Well,
then they move it.
Well, the law's a little bit different in Massachusetts.
Yeah.
There's actually case law that's in Massachusetts. Massachusetts is a quirky state. We have our own little laws and procedures, and Massachusetts says no, you don't have to wait for that. Massachusetts law, and that's in one of these motions. I have 10 different motions up, ready to go. But what I want to look at now is the defendant's motion for leave to conduct attorney-conducted voir dire and for preliminary instructions, which is a totally different thing. But let us take a look at the voir dire. This is kind of a look inside, folks, of what, you know, the attorneys want to do in this case. They want to do extensive voir dire. This is the defendant's motion for leave to conduct attorney-conducted voir dire, and rather going into the depths of the argument that they're making, this is the type of voir dire. I guess I skipped over an explanation of what voir dire is, and Massachusetts didn't really get up to speed on this until more recently, and by more recently I'd say probably the last decade or so. Voir dire means having the opportunity to ask jurors in advance as to whether they could still sit and be objective. We don't ask what's called the magic question. Oh, despite everything you've read in the paper, could you still be objective? No, that's not enough, because somebody that wants to get on the jury will just say yes. So what you do is you ask more pointed questions. And these are the areas that Brian Walshe's attorneys want to get into. The effects of graphic testimony and photographs regarding purported body parts, including purported tissue, blood clot, skeletal muscle, bone, video of the purported distribution of remains of a deceased spouse, of biological evidence found at various locations, including trash collection locations, and found in the basement of the home, and the ability to remain fair, unbiased, and impartial. Now, I don't know. This gets into a little bit more detail than just have you read anything.
Yeah, that's funny because we weren't able to get into this in the Koberger case. This is public, right? So they're talking about what they want to question the jury about, and I don't know if they're going to do a jury questionnaire in this case, but
yes,
they will.
Yeah.
So they're telling us what they want to talk about or ask the jury about, and it tells you what the case is like, you know, what the case is about, what evidence is going to be shown, you know, and whether the jury has problems being fair in a case where there's going to be body parts of or dismemberment of a spouse. Just how they feel about making a decision on a case like that. But in the Culbertson case, we never really got to see that. And I don't understand why.
Well, yeah, as you know, Idaho and Massachusetts are two totally different states, and we have questions about the Koberger case, which we're going to mention in another episode coming up.
But then number six here says, what motivates an otherwise reasonable person to act in a particular manner? That's an interesting question.
Isn't it? Violence alleged to have occurred within a family home for, I think you were correct in skipping some of these, the effects of exposure to unrelated and shocking allegations of homicide, the effects of publicity, broadcast, and social media exchanges about cases of domestic violence, such as has occurred in this case. 9, the ability to be objective in the face of hearing shocking information. Well, what shocking information? I guess that was covered in number 1. Principles of law, a prospective juror's willingness and ability to accept and apply pertinent legal principles, presumption of innocence, burden of proof, reasonable doubt, and an defendant exercising his right to testify. That's pretty standard, I think.
Yeah.
Police officer credibility, and whether it develops in this case that the testimony of a police officer contradicts the testimony of another witness, other things being equal, would a prospective juror tend to believe the testimony of a police officer as opposed to any other witness just because he or she is a police? I've heard this type of voir dire before. I mean, just because someone is a police officer, do you tend to believe them more than another witness? And that's a fairly standard thing to ask jurors.
Yeah, it's just like doctors. I mean, are you more likely to believe that a doctor is truthful rather than a regular witness?
Yeah, reasonable follow-up as to responses to the confidential juror questionnaire. So there you go. There's a juror questionnaire, if allowed by the court, which it will be, as I understand it. So that is a big motion to change venue to be brought so soon before the trial. I can't imagine the judge would be very happy about it either. I mean, I just can't. I mean, I don't know.
I don't know what the rules are, but I'm wondering why they didn't do it sooner. Maybe something has come up. It could be the stabbing. Maybe the fact that he was injured in jail.
Well, it's a fairly standard motion that is brought. It's a fairly standard motion that is brought, and in the memorandum that we're really not going to have a time to go through right now because I wanted to look at some of the motions in limine. They give us a view into the actual strategy and defenses. They did go into that in a little bit more detail, but I found it surprising that it was brought so late, even though they are fairly standard. And the court was shown a whole pile of cases. Now that you bring it up, you want to take a look at some of those? That's fine. We can do that. But this kind of puts the judge on the spot. I mean, if he allows the motion to change venue, that's going to delay the trial. If he doesn't allow it, this can be appealed. And that's not a good thing. This is the memorandum of law now that you've asked. This is the memorandum of law, in fact, in support of the motion for a change of venue. And what the defense did is they laid the court on with some actual cases. The mere existence of pretrial publicity, even if it is extensive, does not constitute a foundation of fact sufficient to require a change of venue. Oh, you think this sounds like it's for the Commonwealth? Nuh-uh. In this 2000 case, a change of venue based on pretrial publicity denied in a case involving killing of a state police trooper, Marc Charbonnier. I remember that case. But in many cases, the facts, however tragic, do not rise to the allegations of the facts and circumstances in the present case, nor does the pretrial publicity match either the tone, content, and extensive coverage in this case. So they're saying, this is not applicable law. This case far exceeds what happened in that case. There are, in fact, cases, as the defendant argues herein, where pretrial publicity alone has been the basis for a change of venue. They cite a 2012 case from the Supreme Judicial Court, which found no abuse of discretion and denied the Commonwealth's appeal from allowance of a motion for change of venue based on extensive pre-trial publicity.
That appeal that the Commonwealth did, that was probably an interlocutory appeal?
It sounds that way, doesn't it?
Yeah.
It sounds that way. It would have to
That
be,
means
yeah.
it was done during the pendency of the case after they got their ruling.
Right.
Yeah.
Based on the evidence to be submitted in his supplemental pleading in support of the defendant's motion, it will be clear that in the totality of circumstances present here, a sufficient foundation for change of venue is established, where it's demonstrated that such publicity will deprive the defendant of his right to a fair trial. And we're only going back to 1997, approximately 30 years. Pointing out that the totality of circumstances standard applied in upholding denial of change of venue based on pretrial publicity. So in applying the totality of circumstances to the present case, any analysis requires consideration of not just the publicity, but the effect and resulting partiality arising out of the allegations themselves, referenced above and not repeated here. Human experience and the attendant publicity lead to the conclusion that the defendant has been generally and substantially prejudiced and that it will be practically impossible to impanel an impartial jury. This is not a case where the evidence of a biased jury pool rests on an argument that prospective jurors only have some knowledge of the accused. See the Angulo case, which again, only about 30 years ago, upholding denial of a change of venue based on the argument that prospective jurors had some knowledge of the defendant. So what they're doing in this brief, the defense attorneys is showing the Commonwealth and showing the judge, it can go both ways, but our argument is stronger than the cases where change of venue was denied. A change of venue has been allowed in some instances based on pretrial publicity alone, in cases which did not rise to the tone, content, or public vitriol believed to be present in this case. And there's a 2001 case, in a murder case involving a retrial after defendant's first conviction was reversed, motion for change of venue allowed due to pretrial publicity and killing of defendant's companion. Commonwealth versus Rankins, a 1999 case. Motion for change of venue allowed in a case involving defendant and wife colluding to eliminate the husband for insurance proceeds. Then we go to a 1992 case, Commonwealth versus Martino, change of venue granted in a case involving strangulation of a girlfriend by defendant. This is what you do in a memorandum. We covered the general idea in the motion itself, and then this attorney, as attorneys are wont to do, filed a memorandum saying, hey, here's all the law that supports what I'm asking for. 1987 case, Commonwealth versus Wilson, change of venue granted in case involving armed robbery and second-degree murder of two men. We go to a 1982 case, Commonwealth versus Harris, change of venue referenced but not discussed in case where defendant killed his mother and sister and a boarder in his mother's home. So I guess it wasn't referenced in that case, but I'm guessing that not having read it, which I certainly would if I was appearing in court, because all you need to totally discredit yourself is to walk into court and have the judge say, well, counselor, what are the facts of that case?
Yeah.
It's not a good, that's not a good day.
No.
But I'm just guessing that a lot of these cases, even if they didn't go the way of the defense attorneys, have a lot of good law. This is pretty much almost what's called string citations, because we just have the citations in parentheses.
And it's just to show that the amount of support that they're trying to put forth, that they have this not standing, but they have a right to change of venue.
Yeah, Your Honor, here's precedent. We want to change a venue, and here are cases that either grant a change of venue or discuss it, at length, and you ought to take a look at that, because if we hold the trial in Norfolk County and he's convicted, this brief shows that we have grounds for appeal. God forbid. I mean, we just saw another case, Karen Reed, tried twice, and I don't think any judge wants that.
No, I mean, it just one and done. I mean, that's the hope.
Yeah. Commonwealth versus Gallagher, change of venue granted in case involving death of defendant's 2-year-old child due to neglect. Commonwealth versus Gaynor, 2005 case where a motion for change of venue was allowed based on prejudicial pretrial publicity in a case involving killing of 4 women. And then a 1977 case, Commonwealth versus Martin, change of venue granted in the case involving robbery and murder of the robbery victim. And so then the brief goes down into the fact that a judge does have substantial discretion, but making the argument that, we just cited all these cases where a change of venue was granted, so that's why we feel that your discretion should be granting us this relief. Then, as we said before, if this is not allowed, we request that prospective jurors be selected from outside Norfolk County. You know what I'm thinking, though, as I read this motion? I'm thinking of the change of venue arguments that were made in the Koberger case. And I recall, because I actually did a live, you know how I love doing lives. I thought it was only going to be an hour long. It was all day. I remember it well. And I think there were 5 experts.
Oh, yes. Okay. Yeah.
So this brief is an opinion. If you're the Commonwealth, you're not happy that this has been dumped on your desk with, only a week until the final pretrial. If I'm the Commonwealth, 1, I'm asking for more time. 2, I'm in the law library saying, well, wait a minute, they cited all these cases. I'm going to find twice as many cases that go my way. Because they're just arguing this. I mean, the defense attorney has one opinion and he's making one argument, and the Commonwealth is making another argument based on their opinion and their research. In the Koberger case, remember there were 5 experts.
Right. That talked about the media and how pervasive the media was and how damaging that was. And they did the surveys. They went all out, I mean, on the Koberger case and then they had that darn hearing where Mr. Thompson was talking about how the surveyors were violating the gag order by saying, asking questions and such. And it was a big drama in that case.
It was a big drama, but they actually had a professional polling company come in and speak to potential jurors, potential veneer men, I think they still call them, that were people out in the public in Latah County, Moscow, and they did a survey of them. And then they had statistical analysts, and then they had professors, and they had... At this second, I don't recall the specialties of all, but my point is that they had very strong grounds based in the opinions of highly paid experts, people with all kinds of PhDs, to say, here are the facts, here's the research, here's what we've got, and here's why you can't try this case in Moscow County. And even though the judge in that case had previously expressed a lot of reservation about a change in venue, and the prosecutor wanted to keep it in Latah County because that's where he was born and raised and went to school and, played in a band and all that kind of stuff. He wanted to keep it there, but after all that, the judge shocked us all and said, nope, I'm getting rid of the case. Of course, he retired soon after that. But anyhow, getting back to this case, this is just opinion.
Right.
Everything
and
we've just said is a...
It's
Go
law
ahead.
and opinion. It's law and opinion, and I haven't seen anything to the extent like research or anything like that, independent research from the defense attorneys about why change of venue should be had. And I don't really know if that's a standard, but certainly in the Koberger case, they went all out. In this case, we'll see what happens, but we'll have to see what the what the Commonwealth says about this change of venue.
Yeah. I just, what I want to do now is just quickly, the Commonwealth, just in the last couple of days before we are recording this episode, the Commonwealth of Massachusetts filed 17 motions in limine, and the defense filed 11 motions in limine. We're not going to go over every single one of them because some of them, I think are kind of, kind of standard stuff. Like they want to do a view. Okay, fine, do a view. They want to do some other kind of
What do you mean a view?
Of the house where this happened. Of the house where this happened. This all happened in the home of the Walshes and their 3 children on New Year's Eve, New Year's Day, 2022, 2023. And it happened allegedly inside of their house and down in the basement. And so it was a rented house, and I can only assume and know that someone else lives there now, obviously.
Well, at least the house is still standing.
You don't knock over a house. You don't knock over a house in Cohasset, Massachusetts. Let me just say that. There have been some very well-known judges in Massachusetts who have lived there, and a lot of other people. It's a really nice town, kind of hard to get to intentionally south of Boston. But let's just go over a couple of these motions in limine because I don't want to spend too much time on them. And the first one I want to take a look at is defendant's motion in limine regarding bad acts. Now, if you'll recall, Mr. Walsh had a conviction, and he was waiting for sentencing on a case in which he had sold some phony Andy Warhol paintings, and he made $80,000 on the sale. And the defense, without reading the whole thing to you, basically says, we don't want that. The defendant has filed a motion for any such evidence without any response thus far from the Commonwealth. Specifically, the defendant moves to exclude any such bad acts evidence, including but not limited to uncharged 2011 allegation contained in an out-of-state police report. Oh, that's a different case. Here's the one I was talking about. Evidence of a fraud scheme and a federal conviction and uncharged allegations of the defendant's mishandling of his father's estate following his father's death. So that one sentence, they kind of, after arguing the law for a number of paragraphs, they kind of put the 3 actual factual charges in the background. There was an out-of-state incident. There is evidence of a fraud scheme and a federal conviction and uncharged allegations of the defendant's mishandling of his father's estate. See how they compressed that all in the one sentence? But the fraud scheme was something on which Mr. Walsh had been convicted, and at the time that these alleged events took place, he was awaiting sentencing.
And it has to do with, fraud has to do with dishonesty. So I'm thinking, that goes to his credibility, and he was convicted. Oh, I think that's fair game.
Here we go with the defendant's motion in limine regarding evidence that biological evidence is bone. Remember that they've reported that a hacksaw was found and bone fragments were found? Well, not so fast. Now comes counsel for the defendant, Brian Walshe, and respectfully moves in limine to exclude any opinion evidence of that biological evidence of, quote, bone, unquote, was in fact, quote, bone, unquote, or human bone. Discovery provided includes multiple references by witnesses that a physical object as well as fragments were purported located in the search of items found in a black plastic bag found in a dumpster, and the object and fragments have been characterized as bone without an opinion that it is in fact bone. These characterizations are a conclusion based on speculation and without any opinion produced thus far that whatever is found is in fact bone or human bone. No forensic testing, including DNA testing, confirmed that the object was bone, much less of human origin. We're going to have to wait and see what the Commonwealth has to say about this one, because Maybe that's one of the things that the media reported inaccurately, and I have relied too much on the media. That
Yeah,
is
that's true. Just the other day, I was hearing things that were inaccurate in other cases that the media was reporting. But bone, I would think that if forensics would have to identify it and, possibly get DNA from it. If that hasn't happened, then I would think that it shouldn't be included, or, that it should be excluded. But, we have to see what the Commonwealth is.
Oh, absolutely. These motions in limine that I'm going through pretty quickly right now were just filed in the last couple of days. Here's another one, defendant's motion in limine regarding witnesses' characterizations of evidence or the defendant's behavior. This one is just saying, and it's been reported that an observation they made was weird, or similar terms, or two, where a witness characterizes an interaction he observed as coaching, or three, statements attributed to Ana Walshe, wherein she reportedly stated, paraphrased here, that she did not know what her husband was capable of. That's pretty incriminatory if that's allowed in. Or four, that discoloration of a section of the bedroom floor in the Cohasset home appeared to have white residue, or the finish had been scrubbed off. So these types of characterizations occurring throughout the voluminous discovery are speculative and unsupported by objective fact. So that's that motion in limine that they want to have that eliminated. The next one is the one that you questioned, defendant's motion in limine regarding a view. So as you pointed out, nope, they haven't knocked down that house, but they want a view.
Yeah, I would think that they would.
Let's see, we have a few more. Here's an order. The court issued an order. I got this mixed in with the motions in limine. This is the court's order on media protocol and coverage. And basically it just says that during the trial in the Norfolk County Superior Court, which is familiar to us all now, journalists have to sign in, and they will only be allowed to do broadcasting or streaming through a pool arrangement. Pool cameras and camera operators shall be in place prior to the start of the session, and equipment shall not be dismantled while the court is in session. The camera operator and other members of the media shall not interrupt court proceedings. So that's fairly standard. That's how it was done during the Karen Reed case. You can't have, there's dozens of, there are dozens of media outlets. When I first moved to Boston, below those many years ago, there were only like 6 TV stations. Let's see if I can name them all. 4, 5, 7, Channel 2, Channel 56, and Channel 58. Now that's only the beginning, and there are a lot of very reputable podcasters and other journalists operating in and around Boston. So that's why it's important that there be a pool photographer, just one camera. One camera. If court starts at 9, you better be set up at 8:30.
Yeah.
And if court goes till 4 or 4:30, you're not leaving until 4:45, 5 o'clock. So that's fairly standard, actually. And so all the media who, they, outwardly to all of us, they're competing, and they have, these ads that we're first, we're the best, we're the only ones. Nobody covers Greater Boston like we do. But they've got to cooperate, and they do at that level. They generally do. So let me see if we have a couple of more motions in limine. There's one more motion in limine that I think is definitely worth our taking a look at. This is the defendant's motion in limine regarding commendations. The defendant doesn't want the Commonwealth bragging that any of their officers won awards. Now comes counsel for Brian Walshe and respectfully moves in limine to exclude any evidence of commendations, awards, or other similar credentials of any law enforcement personnel or laboratory personnel called to testify in this matter. As grounds, the defendant states through counsel that evidence of commendations and awards is not relevant to any issue, is improperly admitted under the guise of qualifications, but is in reality Only good character evidence or evidence intending to bolster the credibility of the witness is prejudicial and should be excluded. Now, I don't know.
Now, they cited a Washington case. Go pull up a little.
Yeah, there's a Washington case.
Now, that's not, that can only be persuasive, right?
Yeah, it's not authoritative, right? You're right.
Right.
Let's tell our viewers what we're talking about. There are a couple of different types of citations and authority. Mandatory or authoritative authority, which would be in Massachusetts. The Massachusetts court has to follow Massachusetts precedent unless there's good faith arguments against it. So they're citing cases out of not only Washington, but New York and Minnesota. So that tells me they don't really have a leg to stand on this. Isn't it fairly standard when you have a police officer on the stand that if they've, or a person from a lab, this pertains to lab technicians also. Isn't it fairly standard that, you ask them about their education, their training, their experience, but aren't you also allowed to slip in if they've won an award or two?
I think so, and I think if the defendants want to bring in, the Proctor's history and being discharged, then the Commonwealth should be able to bring in evidence that certain officers or lab technicians won awards. I mean, it's
well,
fair.
that's what I think you're right, and I think that's what that last motion in limine, which we're not going to read because it just goes into a bunch of relevant but not really that important law, and they're saying, we don't want you telling us if the officers have won awards, and it's like, well, maybe they're bringing this in because a certain amount of the public may or may not reveal during voir dire that yes, they did follow the Karen Reed trial, and yes, they are aware that there were questions about Mr. Buchanan and Mr. Tully and others, and maybe there was a fair amount of publicity in Boston, on the Boston media, about the Proctor hearings. Mr. Proctor, earlier in 2025, in March of 2025, after 3 hearings, January, February, and March, was dishonorably discharged from the Massachusetts State Police. And then there were 2 hearings in the late summer whereby he was appealing to the Civil Rights Commission to get his job back. And in fact, later in October, there are 2 or 3 more days of hearing schedules that I think are going to coincide with this trial. So that's been in the news. And so people, I think, unless they're living in a cave, people are going to be aware of that. So I don't know.
Yeah, that's right. They overlap the Proctor's hearings or whatever.
There was one other motion. The Commonwealth brought or the defense brought a motion to have a barrier or a distance so that if there are protesters outside, the protesters can't get too close to the court. They don't want that distraction. So the protesters wouldn't necessarily be there for the Brian Walshe case. But there are other cases going on in that courthouse, and there were many, many, many protesters outside of the Norfolk County Superior Court during the Karen Reed case. So I don't know. My closing thought, I always put you in the spot and ask you what your closing thought is. My closing thought is that this is motions in limine are pretty standard. Usually a court gives you a deadline, and there was a scheduling conference back in August 12th. Usually a court gives you a deadline for bringing these motions in limine. You've got to bring them by a certain time. But to have that volume of them, 17 filed by the Commonwealth and 11 filed by the defense, and then this motion for a change of venue this close to the trial, that's an awful lot. I can't think that. It is a
lot, and it's a lot for the court to process, but it's a lot for the parties to oppose and, get things together. It takes a lot. I mean, getting exhibits, things, it's a lot of work, and I don't know if they'll be able to get it done in time.
I don't either. So those are my closing thoughts. What are your closing thoughts?
My closing thoughts are, it's interesting to see how cases in different jurisdictions, how the process is done and how things work. It's always interesting. But at least there's more transparency in this case than in the Koberger case. And it kind of follows like Karen Reed's case, the way the procedures go, right?
Yeah, well, it's the same court,
Same
different
court.
different judge, but the same court,
Yeah.
same rule, same Massachusetts rules of procedure, rules of criminal procedure, and the same. That was a good thing that you caught that in that last motion in limine that we looked at the cases. You
Yeah.
noted the one from Washington, but then I looked more closely at it and I saw a case from New York and Minnesota.
Right.
So, I mean, that's not a good day. That's not a good day. I've
No.
always found that the Massachusetts judges very much prefer Massachusetts cases. And not only that, because they're on the bench and it isn't their first rodeo, they often know the cases.
Right.
They often know the cases. I had the fortune or misfortune to argue a appellate case to the Massachusetts Court of Appeals in a dram shop case. And the judge who wrote all of the dram shop decisions in Massachusetts is on that panel.
Oh, wow.
And I had studied them in law school. We had a special project on that issue, so I was just shaking in my boots. And he knew that I had, read all of his cases because he peppered me with questions.
Mm-hmm.
So then he switched over and started asking us fact questions. And so fortunately, I had a co-counsel that lived right in the area where our event had taken place, and he was able to handle all those. So I was like, shh. But yeah, I generally find that the judges that I've been before in Massachusetts, they want Massachusetts cases, and they know the cases.
Yeah.
So, you
Yeah,
know.
if they're deciding cases from other states, it's like kind of like they're grasping at straws a little bit.
Yeah, exactly. Okay, so that's going to be our emoji this week, straw. Is there an emoji for straw?
Straw or drink, I guess, with a straw. Drink with a straw.
There we go. Straw or a drink. Straw or a drink. Okay, all right. Yoli, thank you very much. Thank you. Don't forget to like and subscribe. And be nice to people no matter where you meet them. And be nice to people in our comment section. And so thank you for being with us.
Do you pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. Do you pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.